Our insurance carriers, the E&O carriers, always tell us never, never, never sue a client. With due respect, I tend to disagree. If a client does not pay your bill, I suggest that you do whatever you can to find out why the client hasn't paid, and then, if needed, sue the client. I would suggest before you do any of that, however, you read my book, Collecting Your Fee, Getting Paid from Intake to Invoice, because that book will give you not only the steps in the beginning to assure that you don't get into that position of having to consider suing the client, but also it will give you a script for talking to the client and encouraging the client to pay the bill before you ever have to deal with the issue or the thought process of suing the client. Not long ago, I came across a commentary from the Oregon State Bar, which suggested several tips or steps on how to think about this process, and I'd like to share that with you. First, the question is, do you stand to gain or lose a substantial sum of money? In other words, have you not taken care of the client? Have you not taken care of this account receivable before it got to be very large? If it's not very large, then perhaps it is the least expensive lesson you'll ever learn by forgetting about it and moving on. If it's a substantial sum of money, and of course that word has personal definitions and everyone's will be different, but if it is a substantial sum of money, the first thing I would ask you to ask yourself is, why did I let it go so long? How did it get to this point? But the second issue that the Oregon State Bar suggests you ask yourself is, did the result you attained for the client coincide with what the client wanted? In other words, was it a good result? Because if it was a bad result, you know right away you're going to get countersued, if not sued initially, for malpractice. So that's something that you have to consider in the underlying case. Next, they're suggesting, and this is something I've suggested for many years, is have you had an independent counsel review your file? In other words, peer review. Have you had somebody look at your file and say to you, there really is no negligence here? Yes, a claim may be asserted, but it will not be considered valid. You did everything you were supposed to do, and no negligence is apparent from the file. Next, are there any grounds in which the client can credibly contest your fee? In other words, was there double billing anywhere? Were any mistakes made in the calculation of the billing? Did the description for the services delivered adequately set forth what it was that you did, and what you described, was that in line with what the client expected and wanted and what was needed in your particular matter? Have you ruled out client dissatisfaction as a reason for not paying? In other words, there are multiple reasons why a client won't pay, at least three that I can think of off the top of my head. One, they're dissatisfied with the service that you delivered. Forget about the result, but they're dissatisfied with the service, and their only way of complaining is by either slowing down the payment progress, that is, progress payments, or by not paying at all. So have you ruled out dissatisfaction as the reason? Have you ruled out that perhaps the client or the client's business has gone south? In today's economy, that's an important issue. So if the client doesn't have any funds to pay you despite good intentions, perhaps it's not appropriate for you to sue, because you're not going to get blood out of a turnip, as they say. No point in wasting your efforts if the client, in fact, cannot pay you. Third, did you do what the client expected you to do? take a look at your engagement agreement. And here I'm assuming you have a written engagement agreement. What does it say? What did the client ask you to do? And in fact, did you do that? So these are three issues you have to look at before you ever contemplate suing a client. Have you offered to arbitrate or compromise the debt? One of the things that I think is maybe important here is that taking something, assuming it's 50% or even more of what is claimed to be owed, and then never dealing with that client again, may be the best solution for you, may be the least disruptive solution, the most economically proficient and efficient solution for you. But again, if you take that kind of a discount, don't go back to the well and deal with this client in the future. Some clients, especially for the larger firms, know that come September, October, November, and especially December, they can offer substantial discounts to what is owed. And the lawyers will take those discounts because it impacts the lawyer's compensation schedule for the following year, or even for the current year. Clients know this, and so they do it routinely. That's a client you ought not represent, because when you think you're billing and receiving $150 an hour or $500 an hour, whatever the number is, in fact, you're not. Your realization rate is significantly less. The amount you're getting paid is significantly less. And so be cautious in this arena. The last one is, what about the publicity you're going to get from suing a client? There are two ways to look at this. One, the publicity you get is going to paint you as well as other lawyers in a bad light. On the other hand, it's also possible that some clients will wake up and recognize that you believe and that you know that you are in business and that this is an appropriate avenue to take. And if you're going to be a son of a gun with a client to collect the bill that is legitimate and that is owed to you, you're going to appropriately represent this client in the future in other matters. The lawyer who does not take care of himself or herself when dealing with a client is a lawyer whom the client and other clients who learn of this will not respect and will not bring their matters to you. It's not a question of being mean. It's a question of appropriately and even-handedly dealing in a business-like way with clients to cause them to honor their commitment to you. After all, an engagement agreement, in my opinion at least, is a two-way street. You agree to do certain things in representing the client, but the client also agrees to do certain things, such as paying your bill, as part of this contractual relationship called an engagement agreement. It should not be forgotten. Think about all these things before you actually prepare the complaint to sue the client. Thanks for joining us today.